The following program is brought to you by democracyatwork.info. Broadcasting from a U.S. colony, my name is Andrew Mercado-Vázquez, and this is Puerto Rico Forward, a program that takes a look at the economic and legal structures at play between the United States of North America and Puerto Rico. Without a doubt, the most important subject within the Puerto Rico issue, the archipelago status has profound implications in every aspect of its development. Puerto Rico is neither a state of the North American Union, nor is it a sovereign republic. It is a de facto colony that carries the euphemism of commonwealth in English and Estado Libre Asociado in Spanish. In my experience, the legal theory that defines Puerto Rico's relationship with the U.S. is often difficult to explain and hardly understood due to the unique legal space it occupies. Now, to properly understand Puerto Rico's current political status, the following sources of law must be consulted. First off, the Peace Protocol of August 12, 1898. Second, the Treaty of Paris of December 10, 1898. Third, the Territorial Clause of the U.S. Constitution. Fourth, the Insular Cases of the U.S. Supreme Court. Fifth, the Foraker Act of 1900. Sixth, the Jones-Stafford Act of 1917. And seventh, Public Law 600, signed July 3rd, 1950. Now, as you can see, we have quite a bit of ground to cover, so let's get straight to it. Now, as I mentioned in the pilot episode of this program, the U.S. and Spain became intertwined in a bellic conflict during the Spanish-American War. Lasting only 115 days, on August 12, 1898, a peace protocol was signed by Secretary of State William R. Day in representation of the U.S. government and His Excellency Jules Cambon representing Spain. Article 2 of the armistice explicitly required Spain to cede Puerto Rico to the U.S. Here we can see that the U.S.'s first actual legal claim to Puerto Rico takes the form of a transaction. In exchange for peace, Spain hands over Puerto Rico to the U.S. The exchange was completed when on December 10, 1898, the U.S. and Spain signed the Treaty of Paris, thus ending the conflict between the two. It's important not to forget that since 1508, Spain was the colonial owner of Puerto Rico and thus had the legal capacity to cede it to the U.S. In much the same way as you can dispose of your property, Spain simply gave Puerto Rico to the U.S. without the consideration or consultation of the people. Under this new ownership, Puerto Rico would begin a long and tumultuous process in order to define its political relationship with the U.S. Actually, Article 9 of the treaty gave Congress complete discretion as to the determination of the civil rights and political status of its inhabitants. But even if this article weren't in the treaty, Congress still had its own constitution to back it up. You see, Article 4, Section 3, Clause 2 of the U.S. Constitution contains what is called the Territory Clause. Under it, Congress has, and I quote, the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. End of quote. In his commentaries on the Constitution of the United States, Justice Joseph Story, one of the most important and prominent figures in early American jurisprudence, indicated, and again I quote, as the general government possesses the right to acquire territories, either by conquest or by treaty, it would seem to follow, as an inevitable consequence, that it possesses the power to govern what it has so acquired. The territory does not, when so acquired, become entitled to self-government, and it is not subject to the jurisdiction of any state. It must consequentially be under the dominion and jurisdiction of the Union, or it would be without any government at all. End of quote. In any case, under the Treaty of Paris, Congress was empowered to decide without considering the territory's needs how the people of the territory would be governed. It wouldn't be until April 12, 1900, that Congress, after 2 years of U.S. military rule, would approve the Foraker Act, which allowed Puerto Rico to have a civil government, with the majority of the officials being designated by the U.S. President and Congress retaining ultimate veto power over any law approved by the newly created legislature. Democracy at its finest, truly at its finest. Now, besides its function as a government blueprint, the Foraker Act's capacity as an economic instrument allowed it to control Puerto Rico's economic life. For starters, Section 2 of said statute made it impossible for Puerto Rico to negotiate commercial treaties with other countries. Also, Section 3 indicated that Puerto Rico would not be able to set its own tariffs and applied a tariff equal to 15% of those prevailing in the U.S. on foreign products. Although the law had other sections, such as the retirement of the Puerto Rican peso at a rate of 60 cents and a requirement that all goods moved between the U.S. and Puerto Rico be carried by U.S. shipping lines, it was the 15% tariff that would serve as a basis to question its constitutionality. With the exception of the Treaty of Paris with Spain, up to that point, every single territorial cession made since the time of the Confederation had contained some sort of stipulation to the effect of the newly acquired possessions' incorporation to the U.S. With Puerto Rico being the exception, it wasn't all that clear if it was an incorporated territory, and this was no minor detail considering the constitutional implications. If we accept the premise that Puerto Rico is a territory of the U.S., a question would naturally arise as to the extent to which the dominating country's legal structures, in this case the U.S. Constitution, would be perceived by the inhabitants of the possession. Such a question was actually considered by the U.S. Supreme Court in a series of opinions later known as the Insular Cases. Now, the Insular Cases are a total of 6 Supreme Court cases that have had a huge role in shaping the U.S.'s relationship with its territorial possessions. Although all the cases should be studied, Puerto Rico was directly impacted by the court's decision in Downs versus Bidwell. In this case, the plaintiff was seeking to recover back the duties he was forced to pay in order to import produce from Puerto Rico to New York. The basic contention was whether Section 3 of the Foraker Act violated Article 1, Section 8 of the U.S. Constitution, which reads as follows: "The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States." As mentioned before, Section 3 of the Foraker Act required a duty equal to 15% of that collected on merchandise from foreign countries to be levied upon like articles imported from Puerto Rico. Since Article 1, Section 8 of the Constitution requires that all duties be uniform throughout the U.S., the court had to consider if Puerto Rico was a part of the U.S. and therefore subject to the Constitution's mandate. If so, Section 3 of the Foraker Act would be unconstitutional since it would be impeding a uniformity of tariffs throughout the United States as the Constitution required. To solve this issue, the U.S. Supreme Court came up with a very interesting solution. In order to decide if the aforementioned constitutional text applied to Puerto Rico, they first needed to figure out if Puerto Rico was an incorporated or a non-incorporated territory. The court decided it was the latter, and as a result, Puerto Rico belonged to, but was not a part of, the U.S. Ironically, as a result, Congress was allowed to use its plenary powers, as described in the Constitution's Territorial Clause, to treat Puerto Rico without regard to the Constitution. This, ladies and gentlemen, is a watershed moment for Puerto Rico's territorial status. This case is currently still good law and marks the birth of the legal foundation upon the Puerto Rico-U.S. relationship would be constructed. Puerto Rico belongs to, but is not a part of, the United States of North America. After the court's decision, it would be 15 years until Congress would approve another historical piece of legislation. On March 2nd, 1917, the Jones-Shafroth Act was signed into law by President Woodrow Wilson, changing Puerto Rico's legal landscape once again, this time to a personal level for Puerto Ricans. Section 2 of said statute incorporates a Bill of Rights that generally reflects that contained in the U.S. Constitution, but also Section 3 actually prohibits any taxation whatsoever to be applied to any government bonds issued by Puerto Rico. That said, it's Section 5 which contains the most important change of all, the extension of U.S. citizenship to Puerto Ricans. From that point in time onward, Puerto Ricans would occupy a strange place within the social, economic, and legal landscape of the U.S. On the one hand, we're legally full-fledged North American citizens, but our nationality is that of a people whose motherland has been taken by a country that refuses to let it into its union while unwilling to allow its freedom. The Jones-Shafroth Act, not to be confused with the Jones Act of 1920, would serve as Puerto Rico's legal blueprint for over 30 years. However, it wasn't very long until Congress was at it again, and on July 3, 1950, Congress enacted Public Law 600, authorizing Puerto Rico to, and I quote, organize a government pursuant to a constitution of their own adoption, end of quote. As a result, Puerto Rico was allowed to develop and adopt its own constitution, and I really want to emphasize the fact that Puerto Rico had to be allowed, in other words, given permission by Congress to embark on this process. Although easily overlooked, the U.S. government's autocratic nature towards Puerto Rico can be observed in the law's procedural requirements. First off, Section 3 imposed a two-step review, first by the President of the United States, and second by the U.S. Congress, in order for Puerto Rico's constitution to become effective. Also, Public Law 600 didn't actually repeal the Jones-Shafroth Act in its entirety, but rather specific sections. The surviving text would become the Puerto Rican Federal Relations Act. You see, in spite of the fact that Puerto Rico was able to develop and adopt its own constitution, it would be preposterous to believe that the U.S. government gave up any of its power over Puerto Rico. Case in point, Public Law 447, approved July 3, 1952. Now this is fascinating. Under this joint resolution, Congress approved the Constitution drafted by the Puerto Rican Constitutional Convention, but first, it performed a few edits of its own. Actually, as recent as 2016, in a case called Commonwealth of Puerto Rico versus Sanchez Valle, the U.S. Supreme Court gave a succinct summary of Public Law 447 and its relation to Puerto Rico's constitution, and I quote, "Before giving its approval, Congress removed a provision recognizing various social welfare rights, including entitlements to food, housing, medical care, and employment, added a sentence prohibiting certain constitutional amendments, including any that would restore the welfare rights section, and inserted language guaranteeing children's freedom to attend private schools." End of quote. Now, one of the key motivators for the U.S.'s interest in providing Puerto Rico with an apparent level of autonomy was the pressure it was receiving from the international community. It's important to remember that after the Second World War, the concept of self-determination was at the center of the development of international relations. With such a political climate, colonialism became a nasty word, so much so that the UN drafted a list of non-self-governing territories, and Puerto Rico was on it, and the US was not happy about that. You see, each listed territory's ruler was required to prepare a report for the Secretary General of the UN, on a yearly basis actually. Said reports would have to contain information relating to the economic, social, and educational conditions of the territory, thus providing a public and international forum that would allow scrutiny and criticism, not to mention its cost, logistical burden, and the international embarrassment of being subject to such measures. As we can see, Public Law 600 allowed the U.S. to escape such requirements by serving as the justification for Puerto Rico's removal from the list of non-self-governing territories. After all, what screams self-government more than a good old constitution, even if it doesn't represent the will of the people? Now, before signing off, as I've done before, I'm just going to suggest some literature about the Puerto Rico issue. The Harvard Law Review wrote a couple of pieces about U.S. territories, and it focuses quite a lot on Puerto Rico. I do need to make one caveat. I do not subscribe how the Harvard Law Review presents the issue of territorial federalism. I'm not going to get into it, but to me, territorial federalism as described in the Harvard Law Review just seems like a more refined colonialism. Well, that's going to do it for this episode of Puerto Rico Forward. Thank you so much for your time. Thank you for listening. Y que viva Puerto Rico.